Hey everybody, how's it going? Welcome back to Copper Jacket TV. Do you remember when Illinois Senate President Don Harmon said this?
We'll see you in court.
Well, Mr. Harmon, you were right. Sit down, buckle up, because this is going to be good. We have multiple lawsuits filed in the state of Illinois trying to overturn that state's unconstitutional so-called assault weapons ban. So let's talk about them. This channel is proud to be sponsored by the USCCA. I myself have been a member for the past 5 or 6 years now, long before I ever had any type of relationship with them. And I got to tell you, it's the best peace of mind that you could ever have, knowing that if you ever have to defend yourself, there is a phone number that you can call. An attorney will be provided for you so that you don't have to speak and get yourself in trouble. There's also online training and education to teach you how to deal with an event should you find yourself in need. And there's just a lot of great resources like CCW maps and so forth. And it's really affordable and 100% money back guarantee. So make sure that you check them out down below. If you haven't done so already, please subscribe to the channel. I would really appreciate it. And a little bell notification will let you know when videos come out. Let's get to it. So as of right now, we have 4 different lawsuits, which is fantastic. These lawsuits challenge not only the constitutionality of Illinois' new law, but they also challenge the procedures in which these bills were passed. So they are basically alleging that Illinois' legislature violated the state constitution by the way that they got these bills through without any public comment or hearings or anything like that. This is what we call a gut and amend. So they take a bill that's completely irrelevant to the end topic. It could be about taxes, it could be about water, it could be about just about anything. They move it through the process, and before it actually gets voted on, they take out all the language from the bill, and then they replace it with what they actually want to vote on. So in this case, obviously the ban, right? So they use that gut and amend process in order to kind of circumvent the process and not allow people to have their voices be heard before something as serious as this is actually voted on and then, eventually passed. So again, they're going after not only the constitutionality, but the procedure in this. So this lawsuit is being filed by individual gun owners who are saying that it infringes on their Second Amendment rights. And it is also being filed by some major advocates as well. So we have Firearms Policy Coalition, the Second Amendment Foundation, Illinois State Rifle Association, retailers, and so forth. There are a lot of people who have jumped on board to try and stop this from happening. So Illinois is covered by the 7th Circuit Court of Appeals. The 7th Circuit is very similar to the 9th Circuit in the way that they rule on these things. As a matter of fact, the 7th Circuit has ruled on bans like this in the past, and they ruled in favor of the state. And that's because they've used the interest balancing approach, just like the 9th Circuit does. So the 9th Circuit has held up everything that the state of California has put through because of that balanced, interesting approach. Basically, what they've done in the past is they said that the state's interest overweigh the people's rights. So the state basically says that there's going to be some type of irreparable harm. They try and prove that, and that their interest in passing this law or having this law remain is of higher value than people's rights or whatever infringement it might place upon them. That's pretty much what they've done in the past, but that is all out the window. So we have the Bruin decision now, which says that you can't do that. You can't use the interest balancing approach. You have to use text, history, and tradition. If it's not something that exists in our nation's, historic tradition of firearms regulation, then it can't stand today. It would be deemed unconstitutional. So even though the 7th Circuit, again, covering Illinois, has ruled against us in the past, they have almost no choice here but to move forward and basically, put their vote towards the Second Amendment. Now, here's the thing. People are going to wonder, is there anything like this in the past that they can look at? Any type of historical analog, any type of historical context that they can use? Well, I can tell you just based off of a very similar lawsuit that exists in California. California and the California Department of Justice has just given the 9th Circuit Court, or not the 9th Circuit Court, but Judge Benitez in California, their historical tradition that they found. And it has absolutely nothing to do with the ban at all because it just doesn't exist. So the California Department of Justice has already proven that there is no historical analog for this, and so that means that Illinois and the defendants in this case are not going to be able to find any historical relevance to it either. So the 7th Circuit's going to have their hands tied here. If there's no historical relevance, they're going to have to overturn the ban. So what can you expect next? Well, the first thing that everybody's going to try and do in these cases is try and put some type of hold on the enforcement of these new laws, because right now it's putting a pretty heavy burden on just about everybody in the state of Illinois. So they are going to try and put a stop to it until their case can be heard by a higher court, and that court, gives its decision and so forth. Maybe there's going to be some appeals. They want to make sure that it's not going to be enforced until that point. Now, if they don't get an injunction, if they don't get a hold put on the enforcement of these laws, then the next step is going to be to move it along as fast as possible. We all know that these court cases can take years. I mean, look at California. Some of these take upwards of a decade before they're finally resolved. But you have to remember one thing here. California's case is almost over. California's case has already been through the entire process. It's back down to where it originally started, but we should see a resolution in California's case fairly soon. And if it goes our way, which it looks like it will, then that's going to offer some precedent that we can use to support our claim to the Seventh Circuit or any other court that is in the state of Illinois showing that it's clearly unconstitutional. So that Ninth Circuit ruling in California could eventually help other states like Washington, New Jersey, New York, and everybody else, all the other 9 or 10 states that have introduced something similar to this. So again, 4 lawsuits going after not only the constitutionality, but the actual procedures in which were taken in order to make these things happen. So if they can say that they broke procedure, if they violated state law in doing this, basically invalidates the law altogether, and we wouldn't even need to worry about these lawsuits because, well, it would make the bills invalid, so there would be nothing to enforce. So fingers crossed for all of them that they all, go our way, and we'll see what happens, and I'll keep you guys up to date when I learn more. But I want to thank you all very much for watching. Please like, subscribe. Have a great day.